Here we go. All right. Hello, inventors and entrepreneurs. My name is Andrew Krause, and I'm one of the co-founders here at Inventor Groups of America. Stephen Key and myself co-founded a company called InventRight 23 years ago, where we coach inventors to license their products. Now, through that company, InventRight, we've spoken to inventor groups across the country for over 2 decades, a really long time. We realized that there was no one out there supporting inventor groups. So we started IGA, Inventor Groups of America, to do just that. Then we decided to expand our help to include free educational webinars like this for inventors everywhere in the United States and around the world. At IGA, we provide individuals with options on how to best commercialize their product ideas, as well as strengthen and support inventor groups throughout the US and the world. We have a directory of local and regional inventor groups on our website. If you are located near one, we highly encourage you to join. We would love to hear your name and what state or country you're from. So open up the chat box right down there at the bottom, click on chat, and let us know. Let us know what state and country you're from. And also type in a note if you're new to IGA and this is your first time you're attending one of these meetings. Please do not disclose anything that is confidential and is not already publicly available. Even if it's in a private or to the entire audience in the chat, just don't disclose anything that isn't already publicly available that you want to keep confidential. If you have any questions for the speaker, please type in the chat as they come to you. We'll choose a few questions or maybe quite a few questions to answer at the end or maybe even during. So it's kind of it'll be fun. I think you guys are really going to enjoy this if you're new to this. And hey, if you're coming back, you must have enjoyed it enough to come back at least one more time. So now I'm going to turn things over to IGA's director, Madeline Key, who's going to introduce our very special guest today. Madeline?
Thank you, Andrew. Hello, inventors and Inventors Groups of America. I'm so pleased to see so many of your faces today. It's wonderful to be gathering again. I'm extremely excited for this meeting because we have with us the talented Mr. Eric Blatt. Today, Eric is a patent attorney at Scale LLP. Prior to becoming a patent attorney, he reviewed patent applications at the USPTO for 6 years. I'm particularly excited to have Eric with us to discuss everything you've ever wanted to know about patent examination, because today, as a patent attorney, he advises emerging companies on intellectual property and strategic transactions. He is fully aware that inventors don't only need to patent and prototype their ideas, they need to have a plan for getting to market, and they need to think about their intellectual property with that plan in mind. He serves as a mentor with several accelerators, including the U.S. Navy's SBIR, STTR Transition Program, the Department of Energy Startup Studio, and Georgetown University's Venture Lab. So although today we're going to be focusing mostly on patent examination, there are so many things Eric could speak to, and I highly encourage you to follow up with him on LinkedIn and follow his work. That's where I got to know him, on LinkedIn. He's an extremely helpful person. So Eric, welcome to IGA, and thank you so much for being here.
Thank you, Madeline. It's a pleasure to be here. I'm honored to be invited to speak with your audience. I was thinking that I should do an introduction to myself, but you've covered all the bases. So thank you. Great job.
Very glad to hear it. Just so you all know, Eric has prepared some slides, so we're going to start there with kind of some basic information, and we know you really would prefer to have your questions answered, so we're going to start doing that after we've heard some of this basic info, and feel free to take it away, Eric.
All right, awesome. So it's nice to meet everyone, and I apologize in advance. I went for a run like 20 minutes before this webinar, so my face is a little bit flushed. I don't normally look like this, but it's nice to meet everyone. So I do have some slides that I'm going to talk through, just have a little bit of direct presentation so we can get a little bit of content out there. I would very much like for this to be, a live discussion. If people have questions, I'd love to answer those. As Madeline highlighted, I have a little bit of an interesting perspective. I worked at the patent office for 6 years. I reviewed hundreds, maybe thousands of patent applications. I have done a lot of patent litigation for very high-end firms in big cases. I understand how patents operate in a business context, how they operate in a federal district court, how experts opine on them. And then I also have experience navigating patent litigation inside the patent office before the Patent Trial and Appeal Board. I understand what sorts of issues tend to pop up there, what types of arguments are persuasive, and how to position a patent for optimal likelihood of success in that format. And then the final area is I work, a lot of patent attorneys really focus on serving a small number of very large companies. And they're really optimized for receiving, an invention disclosure in a standard format, converting that into a patent application, prosecuting it before the patent office, where the stakes are kind of low because it's patent number, 32,141. And they're just trying to, get their numbers to the point that it's acceptable to the client. From my clients, I tend to do patent number 1, or I tend to do patent number 5 or number 10. And that's a different framework, both because the stakes are higher, also potentially because the financial constraints are more stringent, and then also because with the business model for patent number 30,000 is pretty simple. We're just trying to increase our patent count. Every once in a while, you'll get a high value patent where something is infringing or is going to cover a standard, for example, and there's some money there. But for a small business, a solo inventor, for someone who's filing patent number 1, the strategy is much more nuanced, because a lot of times you're filing patents to serve your business objectives. It's not necessarily about protecting something in the abstract sense where you can go sue someone for patent infringement, but it's about projecting value and having a chip that you can trade at the negotiating table. So I understand all those issues. I'm very attuned to working with folks from that mindset, and I like to think that by working in that space and really specializing in that space, I hope that I do a little bit better job. So with that intro, I'll walk through the content I have here. This slide deck is really kind of inside baseball, how the U.S. Patent and Trademark Office works from a practical perspective. What are examiners doing? What are they thinking? And what kind of arguments can you make so that you're arguing downhill and that you're making arguments that are going to be maximally persuasive to your audience. So hopefully the slide deck, okay, here we go. All right, so a lot of my clients will come to me, and the first conversation they'll have is they'll say, hey, we have a cool idea. We want to patent this cool idea that we came up with. Or maybe they've been working with another firm and they've been patenting what they've been doing. I think that's nice. I don't think it's quite optimal. I think what you should really be thinking about from a patent perspective is, how do I get patents not only on the specific thing that I'm doing, but how do I get patents that my competitors, or that the people that are the companies that are going to license my IP, how do I get patents that cover what people are going to need to do to have a really effective product? So that's a little bit of a different analysis, because you're not thinking about the specific features in your product. You're thinking about where the market is going and how the features that are in your product map to what you could get that's going to block, that particular line of commerce that you're interested in controlling the IP for. So you don't necessarily want to patent what you're doing. You want to patent what your competitors are going to do, or your licensees are going to do. Other things that you want to think about from a patenting perspective, you want to patent things that are detectable. If you have something that lives on a back end, maybe it's a manufacturing process, maybe it's some software in a SaaS service. Those things can be good for patenting, and there are reasons to do that. But ideally, you want something where if someone does use that technology, you could see that they're doing it, or you could see what they're doing and have a pretty good inference that they are doing what your patent claims under the hood, because that allows you to approach them and say, hey, you're infringing my intellectual property, pay me a license, or bring me into the table and let's do business together. The other thing that, and that also works the other way, right? So if you're launching a product, if something's on the back end and no one's ever going to see it, it may be less important for you to have a patent on that, just because your competitors aren't going to know that it's happening, and you can keep it as a trade secret and protect the value that way. The other thing that I encourage people to think about is a patent isn't good for 1 year. It's not good for 5 years. It's good for 20 years. So if you can find something that's going to have value for the full length of that patent, and it's going to be foundational, not just for what you're doing, but for future development. That's the ultimate win. Obviously, not every invention meets all of these boxes. So sometimes you file patents on the things that don't meet all of those boxes, but that's kind of the ideal case for patenting.
Eric, can you give us the 1 minute talk of what a trade secret is, advantages and disadvantages?
Of course, a trade secret is essentially secret information that provides value for the by virtue of its secrecy. So when people say trade secrets, the formula for Coke is what everyone goes to. I don't know that the formula for Coke is really a trade secret. I suspect that if you're a chemist, you could probably get a pretty good idea of what the formula for Coke is. But essentially, when you're thinking about, do I want to patent this or do I want to keep it as a trade secret? I suspect that, so with software, if you can build software and someone's going to license your software, that's something where potentially you can do licensing without a patent. If it's a product and you're really committed to having the IP on that product and monetizing the IP, you essentially, I never want to push people to patents because patent attorneys do that all the time, and a lot of my clients don't file patents because I do other things than patents. But I do think if the goal, if you have a product and you want to license it, you almost have to file a patent application on it, because otherwise you're not going to have something, you're not going to have a trading chip that you can bring to the table. Does that answer your question, Andrew?
Yeah, that was good. Thank you.
I'm actually going to pop in with a quick question as well, because this is already fascinating. So let's say that inventor comes to you, they want to patent what they've invented, what they have, and you're asking them to think about patenting a little bit differently, specifically when you're saying, okay, what are your competitors doing? Do you have some tips and advice for how they should go about doing that research? Or if they really haven't been thinking in that way, do you then become kind of their business strategist in that sense? Or do you encourage them towards some external resources? Because to me, it almost sounds like, rather than that typical patent attorney who's like, yeah, I can get you a patent, you're doing that advising to really get the inventor to be like thinking about their business plan, is what it sounds like to me.
That is absolutely true. I want to stay in my lane to some extent, both because people go to a patent attorney and they're looking for legal guidance. They're not necessarily looking for business guidance. And then also, realistically, I don't have time to spend 5 hours on business strategy for everyone. But I do want, in those initial calls, I do try to put a genuine effort into figuring out, does it actually make sense to file a patent here? Are you going to get the ROI on this that justifies the spend? And if the answer to that question is, we don't really have much of a business plan here, it's just we're hoping to file it and hope, I don't really want to file a patent application that the client is later going to regret. So I sort of say, if you want to file this, I'm happy to help you. My job is to be a service provider. But essentially, I might do this pro se, right? I might file a quick and dirty provisional patent application just so you have something on file, and then go talk to people and see if there really is interest in the market, because it doesn't make anyone happy to file a patent where there's no business strategy behind it. And in terms of kind of helping coach folks through that process of identifying where the market is going, my experience has been that most people do have a sense for which companies are likely to do X. And usually you can think through if someone is going to move in, if the market's going to move in this direction, what are most likely people going to have to do? And so usually that just winds up being a conversation, or I'll suggest you do a little bit more research. I have had folks with it. They come to me and they have sort of not fully formed ideas of what the market looks for and sort of what the state of the art is. And in those cases, I've suggested do a patent search. And I've, a lot of times you can do a patent search on your own. There's some tools that I recommend, and I've done a whole lot of patent searching, so I can do a little bit of coaching on that. And then there's also vendors who will do a pretty good patent search for $500. So that can be a good option as well to just kind of check what you're doing.
Great info. Thank you.
All right. So what's the expectation when you file a patent application? What kind of timeline are you thinking about? You hire a patent attorney, you're most likely going to draft the patent application over 1 or 2 months. Sometimes it takes a little bit longer depending on how quickly the documents come in, how quickly drafts are reviewed. then people are often surprised about this. You don't file it and then the examiner picks it up the next day. You file it and you wait 1 to 2 years, and then the examiner finally picks it up. Sometimes it's even longer than that. And most of the time, about 80% of the time, you're statistically, the first communication from the patent examiner is going to be what's called a non-final rejection. There's a whole bunch of reasons that examiners reject things most often in the first instance. One of the reasons is it's the examiner's job to review your patent application, do a prior art search, and come up with some sort of good faith basis to reject the patent application if possible. And if they allow things too frequently, it sort of looks like they're not doing their job. So sometimes, that first communication is reasonable, it's well-reasoned, they find good prior art, then you have to figure out how to respond. Other times it's way off base, they did a keyword search and they found some keywords in a prior art reference that have, while it's the same word, it really has absolutely nothing to do with your technology. So you receive that and you figure out how to respond.
Eric, I just wanted to comment on that point right there. It boggles my mind how infrequently attorneys explain the process to their clients. Because I talked to so many inventors where they're freaking out. Oh my God, they rejected everything. They came back, they finally examined it, they rejected everything. Why don't attorneys explain that to their clients? And you're saying that's extremely normal. I mean, we're talking like what, 95% of the time at least?
It's about 80%. Yeah.
80.
All the
Okay.
attorneys all know it's coming.
Yeah. Why? Why is that?
I can't speak for why everyone is doing that. I do try to set expectations and give people an understanding of what the pathway is. I really can't speculate.
I think the attorney is like, oh, I'm going to come in and save you. But what they're not telling the client is like, this happens almost every time. And then they're going to come in and save it. It's just, I don't know, just, you don't have to comment on it. It just seems so silly.
The USPTO doesn't share that either. And so, that's not a fact that they're promoting as well. And so I think this is exactly why we're having events like this, is this does need to be like common understanding, right? Yeah.
There's a flip side there too, which is I said that examiners are supposed to do, examiners want to look like they're doing a good job. They're supposed to do a thorough prior art search. They're supposed to reject it if possible. Sometimes someone comes in with a patent claim that truly is patentable, and there's no reasonable basis to reject it. And so the examiner just allows it. And other times the examiner really doesn't do a perfect job searching, and they're up against the deadline and they got to make a decision and they don't have a reason to reject it because they didn't quite search it quite thoroughly enough. And sometimes those slip through the cracks too, and they wind up getting allowed when they really should have been rejected. And in those situations, the patentee, to some extent, you're happy because you got the patent, but in other respects, you have a patent that might not be that enforceable. And there's a whole bunch of inventors out there who get a patent that's just really broad, and they're thinking, this is the patent certificate is on it, the USPTO seal's on it. They're told that it's enforceable. You get a presumption of validity, but the reality is that the examiner just kind of messed up in that particular case, and so there's another kind of mismatch of what inventor expectations are to the reality. Because if you go and you try to enforce that patent, a lot of times you're going to lose. And so it's just, I think there's a lot of sort of information that's missing from folks who don't work in this space.
Sure.
Okay, so you get that first office action. About 80% of the time, it's going to be a non-final rejection. 20% of the time, it's going to be an allowance. Then if you get the rejection, you basically write letters back and forth with the patent examiner. You can also do phone calls. The end goal is to get to an allowance. The patent examiner says, you know what, you've persuaded me. This is an allowable patent application. I'm going to issue it. Then there's a little bit of lag, and then finally it issues. Note that if you have something that really truly is valuable, you most likely should not consider this the end of the process, the patent issuance. If it's something quick and dirty and you just want to get the patent, okay, you're done. You've spent enough money. If you have something where it's really going to be your business, and this is your foundational patent application for the business, I would almost always encourage you to file a continuation, keep another patent application pending at that point, because for all sorts of reasons, including the patent validity note that I just highlighted, you're going to want to, as long as you have a patent application pending, you can go back and you can get different claims. You can get claims with different scope, You can see how the market is evolving, and you can get patents that are covering where the market is moving. And then you can also, if you do want to, enforce or take a more assertive licensing posture, you can say, hey, this claim is pretty broad, we're pretty happy with it, but we want to really validity proof it and make it much more robust to validity challenges. So if we do assert it, it's going to be much harder for the infringer to escape. You can do all of those things if you have a continuation pending. You can't do any of them if you don't file the continuation before the first patent issues.
Eric, I want to share a cost-effective version I share with our InventRight licensing students quite often. People, and I want to get your take on this, people will file a full utility patent. They're so proud that it got issued. And if it's in a really difficult industry, like it's a medical device or some industry where they kind of beat you up in the patent area a little bit, I go, well, that's great, but you're in a difficult industry. I would recommend filing a provisional patent for $60 because they can take a look at your issued patent. They can see what you got and what you didn't get. And if you have a provisional pending for just another $60, so you can say patented and patent pending, you're going to keep them guessing because they can't see that provisional. So there's an extremely cost-effective way to keep them guessing for $60 without even a continuation.
So are you talking about, so is that you're making that recommendation before they file the first patent application, or?
No, after, let's say they have an issued patent, they're really proud of it, but they're still a little worried. I'm still worried somebody might knock me off, or they're so proud that they have this patent. But what I tell them is patent pending is a great thing because people can't see what you got and what you didn't get. But once it's issued, you know exactly what you got, so they know exactly how to work around you. But if you file a provisional for $60, in addition to that issued one, it could have nothing significant in it. You can say patented and patent pending, and you can keep them guessing when you're licensing in the licensing world.
Yeah, that's fair. That's fair. That provisional for $60, I honestly, if I had something that I thought was valuable, I probably would just go ahead and pay for the non-provisional continuation. I think that's $664 of filing fees versus $60. The reason is if you don't do that, then you can't continue to get claims off the original filing date. You need to do the non-provisional to be able to preserve that priority date and get more patents. The provisional, it's true that it's non-public, and it's also true that you can continue to say patent pending. It's just not going to go. You're not allowed to have the provisional go back to your original filing date. So
I understand.
Yeah,
it might be a new material. Yeah,
exactly.
Yeah.
Anything that happened in that intervening 2 years is going to wind up being prior art unless you do the non-provisional.
Right.
Sure. Just to be sure, I don't know very much at all about the continuation. So if I understand that, let's say you gave the example of this is a broader claim, we want to get more clear about that. Would you be able to add anything more to your application at that point, or just make it more specific if you choose to continue it? And how many times can you file a continuation?
As many as you want. It's just so the rule is, if I file my first patent application, let's say I filed it in 2020, and now it's 2023 and my patent's issuing, I get the claims that are going to issue, but if I want more claims, I file a continuation. So a new patent application is going to have its own patent application number before the first patent issues. So patent 1 is issued, now I'm filing patent application 2. Patent application 2, because it's a continuation, goes back to that 2020 date. So all of the publications and the prototypes and the market moving in the last 3 years, none of that is prior art. I get the benefit of that 2020 date. You're not allowed to add new matter, but what you can do is you can sift through your original disclosure and try to piece together sentences and figures that you had, and just kind of strategically pick the things that are most valuable and most important from a patentability, validity, and infringement perspective, and sort of tailor a new patent that covers whatever your business goals are, whether that's broader claim scope or whether that's more targeted to where the market is moving. And the other advantage is you get to go back to the same examiner, and you probably have a pretty good feel for that at that point for what the examiner thinks is likely to be patentable. So it winds up being pretty cost effective because you sort of know what you need to say to get the patent through.
Oh, I love that. Okay, great. Thank you. That's fascinating.
But all along, though, we're paying an attorney to do all this. So you mentioned a patent office fee. That's never the big cost. It's the fee for the patent attorney that's the cost. Yeah.
That's true. Although the continuation, so, if you want to file a brand new patent application, you have to do a description and figures, and that market rates for that tend to be in the range of $8,000 to $12,000 for patent attorneys. The continuation, all that's done. You're just doing the claims. So, a continuation might be $600 of USPTO fees and $800 or $1,000 of legal fees. It doesn't, I mean, at least for most of the companies that I work with, that tends to be fairly inexpensive in the scheme of things.
Sure.
Sure, that's good info.
So I think people, we can probably skip over this slide. You want to get patents and you want to minimize your costs. Understanding your examiner. So let's say you file your patent application, you wait your 18 to 24 months, finally gets picked up by a patent examiner. Who's the person that you're dealing with? Number one, the patent examiner is highly motivated by something that's called a count system. This is the way that patent examiners' performance is measured by their employer, by the USPTO. Essentially what the count system is, every time an examiner does an office action, either a rejection or allowance, there's a certain number of counts that they get, and then basically time credits, work credits. They need to get a certain number of work credits every 2-week period, every quarter, and every year. So essentially they need to, roughly this says they need to get a count roughly every 8 hours or so. It depends a little bit on the examiner's seniority, and it depends a little bit on which work group they work in. But it comes out to about 1 count per day, give or take. The examiners care a lot about this. This is basically how examiners continue to, this is what examiners are trying to do when they're working. They're trying to get counts.
Yeah. Presumably this is how they also move up in the ranks and are promoted and maybe even get bonuses, things like that.
Yeah. If you're at 110% of your production, you have 10% more counts than you need for your seniority, then you get promoted. If you have 90% or 80%, then you get a lower rating and you're potentially at risk of being fired. So you just have to hit your quota.
Got it.
The examiner's job, as I said, it's very easy. If you have signatory authority, if you're a senior patent examiner that's gone through the process to sign allowances, it takes almost no time, if you just wanted to do a bad job, to look at a patent application and say, you know what, I couldn't find anything, I'm going to allow it, right? So that if an examiner were not ethical, they would just allow everything. That's the easiest way to make their counts. However, the examiner's job is to find a sound basis to reject the patent application. So they do need to do a prior art search. A prior art search, they might spend 2, 3, 4, 5, 6 hours, somewhere in that range. And then what the examiner does, they pick up the patent application. They look at the claims. Patent examiners, I talk to a lot of people who talk about how great their patent specification is, how great their figures are. The patent examiners don't read the specification for the most part. A small minority will spend a little bit of time reading it, but specifications are very long, and they're actually not all of that relevant to patentability for the most part. Pretty much everything turns on the claims. So the examiner is going to turn to the claims, make sure they understand what the invention is, or do their best to understand what the invention is. If they have a question, they'll go to the drawings and the specification for that, but mostly they're going to look at the claims. Then they'll do a prior art search. That's a mix of keyword searching and then something called classifications. They'll find the prior art that they think is best, and in 5 hours thereabout, and then they have to write a legal analysis called an office action. So all that's pretty abbreviated to understand the invention, do a prior art search, and do a sound legal analysis. And if they can't come up with a good basis to reject the patent application, that's when they're supposed to allow the patent applications.
So to be sure I'm understanding you, that you said there was about 5 hours for comprehending the claims, researching them, and deciding how to respond to them.
That's right. Yep.
Okay, but that's not a lot of time. So that would really behoove those claims to be written in such a way that the patent examiner can understand, I would imagine, or understand quickly.
Yeah. So that's true. You want to make sure that the patent examiner understands it. When you're drafting claims, it's actually just as important to make sure you understand. So a lot of a claim is essentially a series of bullets, more or less. You don't use bullets, but you use paragraph spacing, but it's just a series of elements, right? And I would encourage people to try to draft those elements And so they understand which of those elements cover what's in the prior art and which of those elements are novel. And just make sure you're spending a lot of effort with those elements that you think the point of novelty, so that they really pop out for the examiner, and that it's drafted in a way that's going to be hard for the examiner to find a prior art reference that discloses just that. It tends to be easy for an examiner to say, here's 5 elements, 4 of them are on the prior reference A, and if the 5th element is in prior reference B, I'm just going to combine those. So if you just have all of your elements be something that these patent examiners are going to find in the prior art, you're going to walk into an obviousness rejection almost every time. So for that limitation, that element that it's supposed to be your point of novelty, just put some time into drafting it in a way that the examiner is unlikely to find prior art for that.
Okay.
I have a quick question for you, Eric. People are typing a lot of questions here, but how do you, this is such a broad question, I'm going to throw it at you anyway. How do you know your patent attorney is doing a good job?
So it's very, very difficult from, I mean, if I were going to look at that work, I could tell whether the work is substantively good or bad. But if I like hire an electrician, I can't tell whether the electrician is doing a good job or not. It's just, it's very domain specific. I guess what I would say is there's certain signs that you can look for. Number one, with all of my clients, I want to make sure I understand the business case. I want to have a conversation with them about what we want the patent to do, make sure I understand what the claim strategy is, and then I always send to the client the claims for their, because the claims are the heart of the patent application. The specification and figures, you have to have them, they have to describe what it does, but the patent examiner isn't really going to look at any of that stuff. They're only going to focus on the claims. And in a lawsuit, it's really all the claims. Licensing, it's all the claims. The claims are 99% of the value of the patent application. And so I send the claims to the client first. I tell them how to review the claims. This is what you need to look for. This is what doesn't matter so much. I want your input on these things. And I try to bring the client in on that drafting process from the start. And so we have, a joint vision of what that patent application is going to look like.
Would it be fair to say that if your attorney isn't asking you questions and not involving you, that there's a good chance they're not doing a good job?
No, they're going off on their own, and they don't what they're going to give you is not going to be useful.
Excellent. Okay.
Very helpful.
But I think I would be thinking about, I mean, if you can evaluate the substantive work, that's great. But I would just be thinking about, the level of trust, your level of comfort with the person is probably going to be the best marker.
Yeah.
But the attitude, well, it's yours now. You just do it. I'm going to go. That would be a bad attitude for the inventor, right? Like, this is yours. You're the attorney.
Yeah, you need to be involved. Yeah.
Yeah. So sometimes the inventor's got a bad attitude about, and attorney's like, okay, I'll do my best. You don't want to be involved. I'll still take your money. I'll file it. And I mean, that happens too, doesn't it? I mean, let's be honest.
No, there's a lot of ways for projects to be mismanaged and patents to be different.
Sure.
Okay, so examiners, a lot of time pressure here. Everyone's working remotely at this point. They're mostly trying to do a good job, but the reality is sometimes, they don't actually understand the invention all that well, and you need to do a little bit of explaining. And that's totally fine. These are reasonable people for the most part. I wanted to highlight, these are two of my friends from the Training Academy when I started at the Patent Office in 2007. I just wanted to highlight this because myself and Scott and Nick, we were all in the same training group. We worked in similar technology areas. And you can just see based on how patent examiners operate and sort of personalities and where they, who their supervisors are, you get very different results, even within similar groups. So Scott is one of the more difficult patent examiners to get a patent through. Your chances of getting a patent allowed by examiners there within the first 3 years of back and forth are 37%. So 63% you wind up not getting patent, abandoning it within that time frame, or continuing to argue back and forth. Nick, by on the other hand, you've got an 87% likelihood of success. So just different personalities. Both of these are good guys. It's just, there's a significant element of luck of the draw with the examiner. And I would say you're also going to make different arguments and amend the claims differently depending on the patent examiner you're assigned to. So I would encourage everyone, if you get an office action, go on patentbots.com. That's the best website for pulling the examiner's statistics, and look at who the person you're dealing with. Look at their tendencies. Look how senior they are. More senior patent examiners have more authority to allow patents, and so that's all helpful information when you're trying to navigate the patent office. This is an element on seniority. This is a study that I did in law school and then later published with a friend of mine who was also a patent examiner. What we found is on the left is the allowance rate over time of a patent examiner. So as examiners are more junior, they have to persuade their supervisors to allow patents, and they don't allow very many. That allowance rate creeps up over time as they become more experienced. And then on the right, that tail is when they're GS14s, primary examiners, they can sign their own allowances. Then it becomes easier to allow, obviously, so their allowance rate continues to climb. And then that portion in the middle, that's when they're up for review to become primary examiners, and you can see that their allowance rate dips quite a bit when they're under that intensive performance review, just to make sure all their quality is good. So just kind of a note here on how patent examiner tendencies evolve as they become more senior. I already highlighted. Go ahead.
Quick question for you, Eric. Okay, so let's say you're doing your due diligence, you go to Patent Bots, you get a sense of what's ahead of you, and you're working with an examiner who is isn't allowing much. He's a tough character. Is there anything you can do? What should you do? Is it time to freak out? What's running through? What do you think should be running through the inventor's mind when they're processing that information? Because that sounds kind of scary. You're like, oh my God, this person doesn't allow any patents to come through.
Yeah, you get assigned to a really tough patent examiner. So two things you should be thinking about when you get that first office action. I guess three things when you get that first office action. I would always look up the patent examiner, figure out what the stats are, figure out how senior they are, what kinds of arguments I need to make. The second thing I would look at is the thoroughness of the office action and whether the examiner has really understood the invention, done a proper search, and given me a technically and legally sound analysis. So a lot of times you'll see the patent examiner, whether they're a difficult examiner or an easy examiner, some examiners do a great job and their analysis is sound. Others will just copy paste the claims, and then they'll give you a paragraph citation, and you look at that paragraph and in the prior art that the examiner is citing, and it's absolutely nothing to do with what your invention is. So you got to figure out, are the citations the examiner is citing in the reference actually disclosing what the examiner is saying that they're disclosing? And then third, which is the prior art close? Even if the examiner is doing kind of a half-baked job, is the prior art actually there? And do I need to make substantive amendments because I really need to do that to get around the prior art? Once you have that assessment of what type of examiner am I dealing with and how sound is this rejection, if you have a sound rejection, you're going to want to think about what your amendments are going to be. If you have kind of a less than sound rejection, you're going to be thinking about, okay, how do I educate the patent examiner? And I would do all of that on the first office action. I wouldn't wait till office action number 5 to get serious about this. A lot of patent attorneys, by the way, patent attorneys make money on every office action response. So if I were trying to optimize for my own profitability, I would want to do not a great job, right? I wouldn't want to get it through on the first pass. So it's pretty, and also patent attorneys are often backed up, right? You get 3 months to respond to an office action for the most part, and extendable to 6 months. When I was a patent examiner, all the time people would wait until that 6-month date and just file the extension of time and get it in right before the time expired. When you're doing that, what that tells me is you're basically behind, and you looked at it 2 days before, you threw something together and you filed it. I think that if I would encourage people to be a little bit more on top of things. Review it up front while you still have time to conduct an examiner interview, while you still have time to talk to the client about what the strategy should be. Do it a little bit earlier in the process. And then also, figure out what your strategy is on office action number 1, because don't just kind of throw something at the wall and see what happens. And do that 4 or 5 times, and then be more assertive about strategy. In terms of how you can further improve your odds of success, I think examiner interviews are by far the best tool at an applicant's disposal. An examiner interview, instead of just writing a letter, my letters can work. These replies can work, particularly with the examiners who have higher allowance rates. Just filing written responses works well. But for folks where you have a little bit of a fight on your hands, where you're going to need to do a little bit more persuasion, examiner interviews are just by far the best tool. What you want to do for those examiner interviews, make sure that you have your strategy lined up. Are we arguing or are we making amendments? For the most part, in an examiner interview, examiners essentially almost never want to admit, hey, you know what, I was totally off base, let me withdraw the rejection. That's not going to happen. The examiner is always going to give you some sort of reason for why their rejection was sound. So you should expect that, and you should figure out, okay, what are the bones that I can throw the patent examiner that don't significantly sacrifice my claim scope? So come in with your arguments for why the rejection was misguided, but also come in with, settling, ways to meet in the middle on the claim scope. And then what you're going to do is you're going to explain the invention, tell a little bit of story. You're going to move to what the prior art is. So you'd say, here's what my invention is. And you probably, when you set that up, you're going to be thinking about what are the specific features in the invention that really add value and are different, that are missing from the prior art. Then you walk through the prior art and say, this is not anywhere close to that. It doesn't contemplate these specific problems. It doesn't have any solution for those problems. Then you're going to, I usually don't go immediately to the claim language. I want to say, here's the important technology difference. Here's a technical contrast. So my invention is directed to this specific problem. Here's the feature that it meets it. The prior art doesn't contemplate that problem. It has no solution for that problem. Do you, examiner, do you agree that there's a technical difference between what the invention is and what's in the prior art? Usually the examiners will say, yes, I agree. That is a difference that I see. Then you need to move to the claims. So you've got your technical contrast, you move to the claims and you say, so that technical difference that you agreed with, this is where it is in the claims. It's in element 3, words 3 through 6. That's where it is. And you see if the examiner agrees that that technical contrast is properly captured in the claims. Almost always the examiner is going to say, no, I think that I see what you're arguing with that hook in the claims. Doesn't really persuade me that it's fully there. And that winds up being a perfect opportunity to say, okay, well, we agree that there's a technical distinction here. You think it's not in the claims, I disagree, but either way, let's just add it to the claims and overcome this reference. Usually, instead of coming in and proposing the First Amendment, I like to give the examiner an opportunity to make their own suggestions. I think that if you can get the examiner to say, why don't you do X, and then you do X, it's very, very likely that the examiner is going to find X persuasive because they've already vouched for it. Sometimes the examiner will say, that's not my job, right? I review the claims, you present the claims. I don't have any suggestions for you. In that case, you say, okay, so, here's the agreed technical distinction. I had actually thought of this before the call. I have some language that I think would work. What do you think of this? And a lot of times the examiner is going to say, hey, yep, that would work perfectly. And then what you do is you package that up in your reply, and your entire reply just says, we talked about this, I explained the invention, the examiner said, this might be helpful, I put it in the claims, this is allowable. And you tend to get pretty good success doing that.
Wow, you really told a story there. This slide was amazing. I love that. I mean, you guys take a picture of this slide. We'll put the recording up, don't worry, but that was really incredible, Eric. That really, I felt like I was with you and the inventor, and you're going through this process with an examiner, and you're explaining a common path. That was incredible. That was great.
That was helpful.
Because people don't want to say they're wrong. They're not going to say they're wrong. That isn't helpful to take that tack. But I love that you're it's almost like you're playing a bit of a chess move a little bit, and depending on, you're anticipating what they're going to do, and you're using that background info to craft a solution, which is just brilliant. We're getting a little short on time here, so if it's all right, I'd love to hop in and pose to you some questions that we're hearing. Jesse asked a great one. Excluding cost, billing hours, isn't it advantageous to have an examiner who critically scrutinizes the application with prior art and claims?
Yes, it depends what your objectives are. A lot of companies, I think there's two types of patents. If I were a company, there's two types of patents I would want to get. I would want to get patents that get me the scope that I need. I cover everything, and I can talk to investors. I can say I cover everything, and I can go to a licensing discussion. I can say, you do this, here's my super broad claim. I would want that claim. It may not be valid. It may be too broad. I still want that claim. I would also want the patents that are substantively reviewed and are honed and have much stronger validity case, so that when I have that licensing discussion, I say, you fall within the scope of this broad claim, and I also have 5 other claims, and look at how narrow they are, and those cover you too. I would want both of those claims. So the answer is yes. I would want a strong substantive examination, but I would also want some broad claims that come out of it, as well as some narrower claims.
Got it. Great answer. Patricia asks, is there a USPTO fee for an office action, or is you just paying your attorney to deal with those?
You get 2 bites at the apple. You pay your $664 filing fee. As a small entity, it's actually less than that as a micro entity. I think half of that, so $300, $400, something like that. You get 2 bites at the apple. So you put the coin in the slot, and then the examiner will give you 2 office actions. After those 2 office actions, you have to file what's called a request for continued examination, which is about the same level of expense, and you get 2 more. You can keep doing that essentially indefinitely until you get the patent or give up. You just pay roughly $600 for every 2 office actions.
Great.
I got one from Carl here. Our folks are everyone from beginners to very advanced, but I think, and you kind of covered this, but if you could cover it very briefly, that would be great, just so people could leave remembering this. Carl says, I have a patent on a product and I have changes to my product. Is there a way to upgrade my patent to the newer design? So, some people are really new. So what do? You got a patent and now, oh crap, I have an improvement. What do you do?
It depends.
What are your options?
It depends.
Okay.
Ideally, when you were doing the original patent, you were thinking about where the market might go, how the product might evolve, and you got a patent on a feature that's still there. Sometimes that doesn't happen. Sometimes you think a feature is going to be really important. 3 years later, it turns out it's not that important. You can design right around it. If that happens, and you still want to have patents that cover your product because you think they're important for licensing or protection or whatever your business goals are, if you still have a continuation pending, what you can do is you can go through your originally filed description and get the benefit of that date, and you can piece together features from your original description that are still patentable, but cover what your new product feature is. That's a good option if you have a continuation pending. If you don't have a continuation pending, you can't do that. And so in that case, you're probably looking at either not having a patent that covers the new product, or you can file a new patent application that's directed to inventive features in the new product.
Got it. Maddie?
Sure. I'm going to try to race through these and squeeze as much information as we can out of Eric. Eric, have you ever heard of talk of a provisional design patent application? Do you think that idea has any merit?
Can you do a provisional design patent application? I don't think you can.
No, you can't. Yeah. But people want it. There's no such thing.
That's a thing that doesn't exist.
No.
You can do a design patent application. Design patents are their own thing. Probably not worth a ton of time. They only cover the ornamental appearance.
Right. And this probably, Gabriel, we can answer your question. Yes, utility patents are more difficult to obtain than a design patent. Gabriel saying my utility patent has been rejected 3 times while my design patent for the same product has been granted. How common is it for the patent office to overlook?
Very common.
Just a
Very
few.
common. The design only covers the design patent only covers the ornamental features. They're also very hard for patent examiners to search. So you wind up getting, I mean, design patents are so narrow that if someone just does the same concept, but just makes it look slightly different, that the design patent winds up being useless. And then the design patent examiners, it's very hard to do a prior art search for designs. That's image searching. You just have to look at a million images. Good luck. And then on top of that, the claim scope is very narrow. So it tends to be pretty easy to get design patents through the patent office. It's much harder to get the utility patents through the patent office, but the utility patents wind up being much more valuable from a business perspective.
Right.
And it's apples to oranges. So if he was rejected with his utility, but he got his design, it's apples and oranges. So it's not like, why did that happen? It's not the same thing at all.
Right. I think we've got time. Christopher Fitzhardy is asking a great question, so we've got to get to it. Obviousness objections can be very subjective. Do you find that U.S. examiners combine too many pieces of prior art, 4+, mosaicing, in their issuing of office actions?
So too many is a loaded question, right? It depends on the examiner. And it depends a lot on how your claims are written. If you write your claims in a way that's just, here's a list of, a recipe of the elements of the pieces in my product, that is a recipe for inviting an obviousness rejection, because the examiner will just find, all of the elements of your recipe and say it's obvious to combine them. What I would suggest doing in that scenario, and this is a little bit hard to do if you're not someone who writes claims for a living, but there are ways to write a claim so that instead of just having a recipe, you have each of those elements tying together in a specific way. So one feeds into the next and processes it in this particular way, or this feature touches this feature in this particular way that achieves that result. And if you draft the claims in a way that the elements sort of tie together, it winds up being, you're much likely to get that type of kind of mosaic rejection.
I got a great question from Joe here, and I'm going to expand on it a little bit. Joe says, why does the patent office only contact the attorney and not the inventor also? So my expansion on his question on why they contact the attorney and not the inventor also is, how involved do you recommend the inventor be, and what are their options there, and what is a good idea and what's a bad idea?
So the patent office has a rule. It doesn't do dual correspondence. It's not going to write to two different people about the same patent application. So if you want to be the party communicating with the patent office, you need to remove your power of attorney from your patent attorney and have the correspondence go to you. I think that's probably not a good idea. The patent attorneys tend to add some value in the process. I mean, people can debate whether they add enough value to justify the cost, but that's the reason. The patent office doesn't want to be talking to two different people who have different, potentially can have conflicting authority. In terms of what's a good idea, what's a bad idea, it really depends. I mean, if you want to control your own patent application and you're good at it, God bless you. If the patent application is important to your company, I think it probably does, and you haven't done a whole lot of patent prosecution, I think it probably does make sense to hire a patent attorney for that. The things that you can do usefully, let's assume you're in the world where you're happy to hire a patent attorney because you think the value is there. The things that you can do to be useful in that process, make sure that you are reviewing the claim. So most likely, if you get a rejection, the patent attorney is going to say, I suggest amending the claims in this way. Take a critical eye and make sure you're not giving up more claim scope than you need. And make sure that the amendment really does capture a technical difference that you think is there between your invention and the prior art. And then sometimes it's helpful for the inventor to join an examiner interview. It's not always helpful. Sometimes I recommend, I used to work at the patent office. I can just kind of, small talk with the patent examiner, make friends with them, and a one-on-one conversation is going to be more effective than having the inventor on the line.
But it's not like the inventor is not included. If the patent office gets back with something, the attorney can go over with the inventor and they can decide together what they're going to do. And the attorney might be reaching out, but they've had a discussion with the inventor, the attorney has. So it's not like the inventor is left out of the conversation at all.
That's right. The attorney is representing the client. Exactly.
Yeah. Right. Yeah. And they might tell the attorney, do this, and the attorney's like, I don't recommend this, but they might go ahead because the client said, no, I insist. It's not like you're at a loss for any sort of control.
No.
Madeline, do you have any others?
No, honestly, there are a few more questions, but I want to be mindful of Eric's time. And I've learned so much from this presentation. I'm very excited to quote you and share some of these insights. I would really love it if everyone, if you could please write in your thanks to Eric in the chat while we're still wrapping up for a few minutes. Eric, if people are just like so delighted with what you've shared, they want to keep in touch with you, what are some ways to follow your work? And if you have any other resources to recommend, we'd love to hear, who you pay attention to and how you learn too.
If you want to stay in touch, I'd love to, talk to folks. Feel free to connect on LinkedIn. I'll drop the link in the chat. I'm happy to kind of send some more resources. Probably the best way to do that is by email. I can just give some links. And then, yeah, if anyone wants to reach out, I enjoy working with inventors, with startups, with small businesses. Also, another note, in addition to, we didn't talk about it a lot, but if your company is interested in government contracts, government grants, the U.S. government does. If you have something that's competitive for that, that's a huge opportunity. I do a lot of work in that space. And then if you are in the position where you have patents that cover what folks are doing and you want to discuss sort of licensing strategy, business strategy, or if you want to make patent infringement claims, I'm happy to have those discussions as well.
You're like, one-stop shop. My goodness.
Let's do a group photo here. If you could stop sharing your screen so we
yes.
can see everybody, and if as many people as possible want to go on camera for the group photo, I'll unhighlight us. We'll remove the spotlight from all of us so we get a nice group photo here. Okay, there we go. Okay, so this is what we're going to do, guys. Give a thumbs up, a wave, a smile, and I'll do a couple screens. Keep it going, keep it going. There we go. I got the first screen, and we got the second screen, and then by the third screen, there's nobody on there anymore that has video. So thank you, guys. That was cool. Thank you for all the Madeline. Did everybody write a thank you for Eric there?
I think so, Eric. I will follow up and share with you all of these wonderful comments. I definitely read that someone said, do you have a book out? You should write a book if you haven't. So there's a lot more that our audience wants to hear from you. And truly, I can't thank you enough for your time. It really means a lot to us that you would spend it with us and be so frank about your perspective on patents. Like there's just so much to learn. It can be really difficult to sort your way through all of this information, and what you've provided is just priceless. So
I want to say something too. I mean, I think that patent attorneys, legal advisors in this area don't always have a business sense about them. Eric definitely has that. So that's very special. That's a huge compliment, Eric. He said so many things on this session that the average attorney wouldn't have said, which tells me he's different. So I thought that was very powerful, Eric. You might be like, oh, that's just who I am, but that's very important.
Appreciate
so thank
that.
you. Yeah.
Appreciate the feedback.
Well, yeah.
It was a pleasure being here. Great to meet everyone. And yeah, if anyone wants to keep in touch, I'd love to talk to you.
Brad, thanks everybody, and we'll see you again next month for our next IGA meeting. Appreciate your time.
Hey guys. Bye.
Bye.
Bye.